since 1951. This is the legend. 105.3, 95.3.
And we've made it to Bulletproof Estate Planning with my good friend Stan Pierchoski. How are you, buddy?
I'm doing great. How about you?
And the weekend is here. We've made it to Friday.
We did.
And you have a lot on the plate, as always, I'm sure.
Yeah, and I between what we do and what we talk about and the news, from last Friday, I just can't think of anything to talk about.
So much. There's so much going on in the world.
From Friday to Friday, it sure was a lot of difference, right?
A lot of difference.
Well, first of all, I need to chime in. I probably shouldn't or wouldn't, but I just feel compelled that Joe's not the only person that can say the alphabet backwards.
Really?
And of course, I do it different. I mean, this is something. This is how I explain this. I mean, I don't know if you're going to consider it odd.
Yes.
Not, but when I see numbers, I mean, I was an engineer. When I see numbers, I can see them in my. You know what you call your mind's eye.
Yeah.
You can see things, right?
Yeah.
Without, but that you're not really looking at. And I can see numbers in my head. And if I say the alphabet, let me do it. If you say the numbers 1 to 10, everybody can do that, right?
Right.
1 through 10, and most everybody can count backwards from 10 to 1, right?
That's correct.
But when you say the alphabet forward, then people have a difficult time saying it backwards. And I can see the alphabet in my head, and if I want to say it backwards, I just look at it and say it backwards because I can just see it.
And that's probably how he does it.
And I mean, I do that a lot with stuff. It's just the way things are. It's just the way my brain works. So I can actually say it faster than he says. I could say it very fast, but no, you do it. But
wow.
So
it's a skill set here.
Yeah, let me just say it backwards.
Okay,
then I want to talk about
the proof is in the pudding.
Then I want to talk about a couple of words. Sorry.
Okay.
I'm gonna close my eyes. So
Here we go.
Okay,
All right, here we go.
ZYXWVUTSRQPONMLKJIHDFEDCBA. They're all there.
I couldn't challenge you on that.
Okay. ZYWVUTSRQPONMLKJIHDFEDCBA.
Well, you did it.
I did.
You did.
And you were talking about words that go backwards.
Yeah.
There was a name for that, which I remember there was a name. I didn't remember what the name was.
Well, we found out.
I heard you say it.
Yeah, it's
but there's
palindrome.
Okay, palindrome. Which spelled backwards? What's that say?
I don't think it spells anything.
It's a word salad.
Yeah.
But there's other words like radar and kayak. There's a list of words that. Now, when I was younger, there was can you make a sentence that spells backwards the same way as it spells forward?
Can you do a sentence?
Which is like multiple words that do that.
Yeah, I don't.
And I've only ever heard of one, but this is, I don't keep, it's not exactly what I spend time keeping up on, but I remember hearing it on something like, I don't know, maybe the Johnny Carson show or something.
Yeah.
But the longest sentence that at the time was a sentence that is step on no pets.
Step on no pets.
Which, I mean, it has to make sense, and that barely does, but.
Step on no pets.
I mean, you could string words together that say the same
thing. And it says the same things backwards.
It does.
How about that?
I don't know that has its own name or not, but.
That's interesting.
Yeah. I mean, there's several words.
So the things we find out.
Yeah.
The things we find out.
That's what you call useless knowledge.
Yes. Well, it's entertaining knowledge.
It is entertaining.
It's entertaining knowledge anyway. That's pretty
good. You're talking about the English language, right?
Oh, yeah, yeah.
Here's an argument I made in court one time that a long time ago. It was entertaining, but do you know that the English language, if I remember right, consists of 526,000 words?
526,000 words.
Right. Okay. Now, the average person's vocabulary, relatively, average to slight to good, above average, is about 15. Let me think about it. But about 50,000 words. Okay.
Okay.
Now that's roughly. I'm trying to do in my head 15%.
Okay.
Or less than that. If I think about it.
Yeah.
10% would be 50. Yeah. About 10% to 12%, right?
Okay.
Now, my argument was I was asking somebody if they understood the English language. And
yeah.
They said absolutely. So I lay these facts out and say I would contend that anybody that only knows 10% or 12% of a subject doesn't understand it very well. And so here we are. If your average vocabulary is 50,000 words, that's 10% of the English language. Because you come up with these words and there's always new ones, right? A lot of them we sure don't need, but I'm just saying there's a lot of them.
There is a lot of them. There is a lot of them. And listen, in their words, but the words, the names of medicines
Oh, yeah.
That, you know, I'm like, how in the world can you keep up with that?
Well, they have the name and then the actual name of the compound, the chemical name.
Yeah.
You know, and, the chemical name is derived. I knew that because when I used to study chemistry in undergrad, and they can get pretty long.
Yeah.
But then they give it a name like a brand name or something.
Yeah.
Like aspirin.
Yep. Well, I'm fascinated.
Aspirin's named after an acidic compound. It's in the compound is acetylsalicylic acid.
That's what I thought. That's what exactly what I
thought. I'm not sure if I could spell it. I could take a stab at it, but not necessary. We just call it aspirin.
Aspirin. That's right. Alka-Seltzer is about my speed. So
there you go.
So there you go. Plain original Alka-Seltzer is good stuff.
How do you spell Alka-Seltzer? Plop, plop,
Plop, plop, fizz, fizz.
Remember the
I sure do.
Commercials.
Yeah. Was that the
Speedy? Remember Speedy, the Alka-Seltzer man?
Oh well, barely. Now I've seen that maybe in some old reels. I don't think I remember the original.
Yeah. But,
was that the was it an Alka-Seltzer commercial with the guy sitting on the edge of the bed going, "I can't believe I ate the whole thing"? That was something.
No.
Do you remember that?
Yeah, I think, and then the relief was the Alka-Seltzer.
Yeah.
Yes, I do remember that. I think it was.
I resemble that remark every once in a while.
I represent that. One of the best Alka-Seltzer commercials, they were advertising a lot back when we were doing a lot of our space race. You know, the Gemini and Apollo launches were going on.
Yeah.
And there was a commercial that showed this giant rocket gantry. And in it, and at the top of the gantry being held by it was a giant Alka-Seltzer tablet. Below it was a glass of water. They counted down 10, 9, 3, 2, 1, launch. And the thing lets go of the Alka-Seltzer tablet, and the Alka-Seltzer falls into the glass of water. And the glass of water starts to fizz, and that was the commercial.
There you go. How cool is that?
It was cool.
The things we remember.
Yeah, so we digress. So, all right, we got a seminar coming up, and it's going to be here at the WLX.
Oh yeah, that's
station.
right.
It's actually 3 weeks from tomorrow. It's March the 28th. We call that Will's Trust in the Nursing Home, and that's what we're going to talk about. So if you hadn't been to one of my live seminars, they're worth coming to. Hopefully the weather will be better than the one I had in January.
And they're no charge.
No, it's a free educational seminar. I focus on the word educational. A lot of people focus on the word free, but no, there's no charge. You can come and listen. If you like it, that's great. If you don't like it, that's okay too. Most people do. But you'll learn some stuff. And actually, you'll learn some things that you hadn't heard before. So, come with an open mind. I always get, I had somebody in my family that was stubborn like that. It's like, well, I'd say something. It's like, well, I never heard about that. So I don't see how that can be. I've never heard that. It's like, well, it is possible there could be something
that you haven't heard
out there that you hadn't heard. Right?
That's right.
So be open-minded. Just because you hadn't heard of it doesn't mean it's not there and not available. Because usually the things that you hear that are new are very enlightening.
Yeah.
Very helpful for you.
Yeah.
They're not negative aspects. They're very good. So.
Yeah, absolutely.
So, anyway, that seminar is on, it's at 10 o'clock on that Saturday, the 28th, right here at the back of the building, in the double doors in the back. Also, I usually do these seminars every other month, as I've said, and I'm doing one in April because we got a special invite from the Marshall County.
Okay.
And through their public library.
Okay.
I'm not sure, but I think they're doing a little something where they have some presentations on senior living of different subject matters.
Oh wow!
And they reached out to us to come and do an estate planning one. So I forget that the girls are working with them on the dates and the times and stuff like that. So I should probably have that by next Friday, and I can talk about that. But so that'll be one we do. We're doing one in March. We'll be doing one in April, and then we'll do another one of our regular ones that we do in May. Because I usually do them every other month, but I do ones that are by request.
Sure.
Usually they're not open to everybody. Like somebody will ask, like the sheriff's department has asked me to come out and talk to all their employees.
Yeah.
So we do. That's not necessarily open to anybody to just come.
Right.
So I don't advertise those, but the public library one is one that's open to anybody who wants to come, and I told them I would help promote it on the radio the radios I'm on. So, we've been in Marshall County before, but it's been a while.
And of course, that's Lewisburg.
Yes, it is. So there's that. And I'll give you more information on that as we get.
Very good.
As they firm those things.
Very good. But you don't want to miss the one here, March 28th. That's this month.
Yeah, we got a big venue over here, and lately I've been drawing pretty big crowds. So, but they fit. Sometimes over here we run out of tables, but we got plenty of chairs and space.
Yeah.
And so we usually bring a bunch of clipboards if you aren't at a table.
Right.
There's really not anything for you to write down at the seminars. Some people take notes. So I recommend you just sit and listen and let it flow.
Yeah.
You stay with it. It's usually good enough, but it's entirely up to you. So,
Yeah.
But yeah, come to it. I'll bring that up again at the end of the show.
All right.
When that's coming up. So.
All right. Well, we got a caller wanting to chomping at the bit to talk to us this morning.
Oh, are they there?
Yeah, buddy.
Oh, I heard it ring, but I thought.
Hey, good morning. You're on with us.
Every time I get like Jeff, I think I've learned it all. I can be a lawyer. I hear of another situation, and it's in a southern state, not a northern state. And it's not your typical husband and wife that's been married before. It's about an older couple who had a family. They grew up, and now in their older age, they have supposedly adopted, other children. I would seriously doubt if they did have a will or trust that this is somebody extended family for somebody else, not for, by marriage, but for somebody else. And I wanted you to cover again how that delineation between stepchildren and adoptive children works, because in some states, and I thought you said Tennessee, that just because they're stepchildren doesn't mean they're in the bloodline as far as inheriting. And then also you've mentioned a couple of times about we honor other people's wills or we honor other people's trusts from other states, but what if they come from a state that has something that is not legal? Let me give you an example. This death with dignity pill has been adopted, and I was wondering if this ties in with the medical directive that would have to be changed. In Tennessee, it's been considered the doctor gives you 6 months to live, and they don't give you the medicine to the patient. Now, this may be way off, but the part about a different type of family and why they might need their will or trust, and especially when it comes to adopted children that might not be in the first will, but I just thought that was interesting. But I was unclear about the stepchildren and adoptive. Does he understand my?
I think so.
I do.
All right. Thank you. Very good. I'll let you tackle that.
Sure. When you, let's talk about stepchildren and adopted children first. That I wrote down. I jotted some quick notes because sometimes you get a little bit off point, and I want to make sure I boil it down to the question.
Yeah, that's right.
So, let's start from fundamentals. A stepchild is not bloodline. If it's your stepchild, it's not in your bloodline. Right off the bat. And so what we refer to is if you pass away and you don't have a will or anything, you just passed away, what we call intestate, with no documentation saying where you want your stuff to go. Right. The state of Tennessee writes one for you. Right. And so they decide where the property is going to go. And there's a search routine that they go through to determine where it goes and how much. So let's say, let's use myself as an example. I got 3 children, and now they will, if I pass away without a will, they'll say, okay, no will, so it's got to go somewhere. So here's the process. We look to see if you have a surviving spouse, and we look to see if you have any bloodline children. The word is descendants. Okay. Yes. Descendants do not include stepchildren. So, and I have 3. If I may or may not have a surviving spouse at the time. But it'll look to my 3 children and we'll give to them, divide equally. And then if I don't have any children, then it looks back up to see if my parents are around. If they're not around, it starts looking sideways to siblings. And so there's this search program trying to find people to give the inheritance to, right? Yeah. Now, if they come across a stepchild, that's not included because it's not bloodline. All right. So if you don't do anything, and you have stepchildren, they're not going to inherit. Yeah. Now, adopted children. It can be confusing because they're not technically your bloodline, but if you go through the legal adoption procedure and you adopt them, legally adopt them, yes, then they are considered under the law to be a biological child. We know they're not physically a biological child, but by the law treats them as if they are. And so they would inherit in that if one of my 3 children was adopted, they would treat it just like I had 3 natural bloodline children. That's correct. But now, the thing that's important to know about this, when if you got stepchildren, which is very common in blended families, there's a lot of folks out there. It's not like a bad news. It's not bad news that they're not in that lineage, right? Right. Because when you're in a trust or even in a will, any testamentary instrument if you want to leave to somebody that's not somebody, you just have to say it. In other words, if I have a trust and I've got a stepchild and I want him to get a share of my stuff, I will say it in that instrument. I'll say I want my 3 children, including the adopted child, to share equally.
Or the stepchild.
I've done that. I said I want all my children, including my stepchildren,
Right.
To get an equal share.
Yeah.
So it just doesn't. They're just not in it if it's an automatic determination, and the automatic determination is if you don't say anything about it. Then the trust code has to fill in the gaps. If you didn't say where it goes, then they fill in the gaps, and the gaps are just our descendants. And so,
Yes.
Again, sometimes that's what you would, like me. I got 3 children. If I pass away and my wife is not, and I'm the second death, I basically wanted to go to my 3 kids, right? I've got some stipulations on it, but basically, if I didn't do anything at all, that's kind of what I would get.
Yeah.
And if you're silent on what happens, the trust code is a bunch of gap fillers, and it's like the default values. So if you're silent about it, that's what you'll get, because the trust code will fill that gap. But you don't have to rely on the gap fillers. You can just say what you want, which is what I recommend. I say, so if somebody tells me they're leaving everything to their 3 kids, I'll ask them at some point and say, okay, I know this is a hard thing to think about, but what if one of your children predeceases you? Where would you want that share to go, that third, okay? And so I say, well, we can say you have a choice. Because a lot of people say, what happens if one of my children predeceases? And the answer is, when I give this answer, I think I sound flippant, and I don't mean to be, but the answer is, it goes whatever we say.
Yeah.
And we have several choices. The one I just described, is called per stirpes. It's a Latin term. It goes to your bloodline descendants, and if any of them predecease, it flows through them to their children, and it just keeps diluting among those. But it doesn't have to be that. Another one's called per capita, which would say if one of my children predecease, then it goes back into the pot and gets divided among my then living children.
Right.
Okay. Now that has all of them have pros and cons, right?
Yeah.
The disadvantage. Well, I don't even know if it's a disadvantage, but one thing you have to recognize about per capita is that if you have a child that predeceases you, this will not go to their descendants. Okay. It will cut their descendants off.
Yes.
Go to the other 2 living children. And then the third choice is basically named people or named organizations. So here's where this comes into play. A lot of people will say, if I pass away, will my children's spouse get anything? And the answer is no, because they're not descendants. But the answer is yes or no, whether or not we say they're going to get anything. So a lot of people say, I don't want this, my in-laws to get it, and that's great. Nothing happens automatically. We just don't name them. But sometimes someone will say, if somebody so passes away, I'm okay with his spouse getting the inheritance. And I said, it's great. All we have to do is say, if Joey predeceases me, then I want Susie gets his share.
Right.
Now, I would go further and add some language in there that says something like, if Susie was his spouse at the time of his death. In other words, we kind of want to, if they divorced 5 years before that,
right.
But again, you could even do that if that's what you wanted to do. Most people don't, but of course, you could give it to the mailman if you wanted to.
Yeah.
You just have to say it. So we just explain where it's going to go.
Yeah.
So I think that answers that one. So I'm still working on number 2.
All right, we'll come back to that if you want to take a call.
Same one.
No.
Yeah, I'll take it. I have it written down so I can come back to that.
Hey, good morning. You're on with us. Good morning. You're on WDXE.
Hey, Jim.
Yes.
I ain't on there, am I?
Yeah, you are.
Well, take me off. I just got to ask you something.
All right. Well, I'll have to call you back or talk to you after 9 o'clock. Okay.
All right. Call me back.
All right. Very good. Sorry about that.
Oh, it's all right.
Sorry about that.
So question number 2 talks, best I could figure from what you said, talking about other states recognizing other states' documentation like wills or trust plans or something. Is that the way you?
Yes.
Okay.
Yes.
And they do. A lot of people, we live in a pretty mobile society where people move around from state to state, especially now. Just to sidetrack on a statistic, that I guess the statistic is a California leaves California every 1 minute and 47 seconds.
That's funny.
So, anyway, if you have a trust plan or a will, or that's kind of documentation, and let's say you do it here in Tennessee, and then you move to, I don't know, Kentucky, another state, any of the other 49 states, right?
Yeah.
if you move there, the question I get a lot is, or people that come here, do I have to get a whole new trust or a whole new will because I'm now in another jurisdiction,
Yes.
state jurisdiction? The answer is no, you don't have to. I mean, there's nothing that says you have to. And the reason you don't have to is because in our Constitution, you will find under Article 1 that all states have to give all the other states what they call full faith and credit. Full faith and credit means, yes, we will do your document, it'll just be governed by the state where it came from.
Yes.
So, if I write a Tennessee trust for you, and you move to Kentucky, and you pass away in Kentucky, and Kentucky does the trust administration, they will do it, and they can do it there. They just do it under Tennessee law.
Yeah.
Now that comes when one of the reasons we came up with the uniform trust code is because of that. You know, we've got several of our codes are what they call the uniform codes: uniform probate code, uniform trust code, uniform vehicle code, stuff like that. There, and it's for those reasons because it's easier to administer things for all the different states. So you don't have to change it just by virtue of the fact that you relocated.
Yeah, okay.
But a lot of times people will come to me and say, I came here from Ohio, I have a trust, but we're living here now. But the Ohio Trust was written 20 years ago, and my kids are all grown, and so we want to make some changes. If that's the case, then we will do a new trust, or we can do what's called a restatement, which is like a revamp of that trust.
Yeah.
And when we do the restatement, we're allowed to change the situs to the Tennessee.
Okay.
And so, but the answer is you don't have to change it just because of that reason. That's not enough of a reason to change it, unless you just plain want to.
Yeah.
But because it will be administered just like it would be if you stayed where you were.
Okay.
Now I don't do probate anymore, but I've probated wills from New York, from Florida. I mean, here over in Giles County, so,
Yeah.
we've done that. It's certainly doable.
Yeah.
You know, so the Uniform Probate Code makes it easy because the laws there are very, very similar to the states that adopt the uniform codes are very, very similar. They have a few little nuances,
Sure.
but for the most part, they're very similar, and that makes it easy for us to do.
Sure.
So,
Makes sense.
Tennessee has adopted Uniform Trust Code. And, and so did I think 27 other states. So there's quite a few. The majority of the states have adopted Uniform Trust Code, and we are one of them. So there may be some issues but so there might be a little more effort or cost involved because you have to deal with the other states' law.
Interesting.
And as an attorney, I don't know the other 49 states' law. I've got some familiarity with some of them. Some of them I understand and are familiar with very much because we deal with them often. Usually your sister states. Ones like you pick something like Utah or something. I mean, I don't they're not a uniform trust state, and I just don't know.
Utah, they're weird out there.
Because we have one of the amendments we have is the 9th Amendment, which is the States' Rights Amendment. So states are they do their own thing kind of.
Yeah.
They have to stay within federal bounds, but they do their own thing. Classic example is like in Louisiana. They still operate under what they call the Napoleonic Code.
Yeah.
And the criminal law there is very, very different than what we practice or what we think of about what we know of here in Louisiana.
Yeah.
Under the Napoleonic Code, as they deal with it, and the jurisdictions are laid out into parishes, which are different than they just draw a district or a county.
Right.
So, the 50 states have their own jurisdiction, but
Louisiana is unique in that.
they're the only ones that do that.
Yeah, they're the only ones that do that. Yeah.
But so the answer is, yeah, you can do it. I mean, it's designed so that you don't have to change it. States will recognize other states' stuff. Now, it goes into other areas too. Like, let's say somebody sues you, or no, you sue somebody. Okay, you sue somebody here in Tennessee.
Yes.
And you get a judgment. And all of a sudden, these people relocate, and they're probably running from the judgment or something. But they relocate in Kentucky. Okay?
Yeah.
You can go to Kentucky and you can do what they call domesticate a foreign judgment. So you go to that court and say, look, I got a judgment in Tennessee on this place. They're now a Kentucky business, and I want the court, we're not retrying the issue, I just want the court to domesticate, meaning domesticate it to that new jurisdiction now so I can collect. And it's a simple thing. You usually draw up a petition, go to court, include the documentation where you sued the person and they got the judgment, and they will simply domesticate it. Now you can pursue. Now you have the jurisdiction to go after them now where they are in Kentucky.
Sure.
So it's the same concept. The states are recognizing what the other states do.
Yeah.
We talked one time, several weeks or months ago, about common law marriage. There's still a handful of states that recognize, will let you do a common law marriage. Let me put it, they don't let you do it. They do what they call recognize it. And then some states just don't recognize it, but some states will say, well, like Tennessee says, we don't recognize common law marriage, but we will recognize it if you have one and come from a state that recognizes it. Now, Alabama has common law marriage, so if you have an Alabama common law marriage and you relocate to Tennessee, Tennessee will recognize it.
Yeah.
I hate to get down a path on that, but recognizing it is where people get confused.
Yeah.
So I'm gonna spend 2 minutes on it since it came up.
Yeah.
I mean, it could have something to do with estate planning if you're in this boat, you know. You know, common law marriage it's interesting. When you think about marriage, it's like, has anybody ever gotten married before the state of Tennessee? I mean, the answer is yes, right?
Yeah.
So, you know, when you get married, they say by the power vested in me and by the state of Tennessee, right?
Right.
Well, before Tennessee existed, did anybody ever get married?
Yeah, absolutely.
So it's a silly question, but the answer is yes. So how'd they do it then, right?
Yeah.
It's called a common law marriage. You get married in the eyes of God, and Scripture is very clear on how to do it.
Right.
It's not much, but you go to the authority that allows marriage, and that is still to this day the only authority that allows marriage.
Yeah.
States just put their finger in the pot. That is really what they're doing because
Yeah.
they're actually. So what it really means is, when they don't, if you don't recognize one, it doesn't mean you can't do it. In other words, if you and your girlfriend get together and you say, hey, let's be common law married, but you don't get a state license and get marriage, and you're living together for 10 years, you know, and something comes up, they're not going to come and say, okay, we don't recognize common law marriage, you guys have to move out and live separately. I mean,
Right.
they don't do that. You can live that way. When they say recognize, it means they're not going to recognize any of the laws that are dealt with married couples. Here's a couple good examples. If let's say you're with this person for 20 years and you have a breakup.
Yeah.
If you want to go into court and get a divorce, they won't give it to you. They say, we don't recognize the union in the first place. Divorce is a statutory remedy for a statutory marriage. And we're not going to give you a statutory remedy for a statutory marriage if we don't have a statutory marriage.
Right.
It's a jurisdictional issue. They don't have the power and authority over it. Same thing goes if you go into court and say, we're breaking up and I want child support for my kids.
Yeah.
You know, that's that famous case with Lee Marvin many years ago, back in the 70s, where they were married for a long time, and she went to court. It was out in California, she was awarded money to take care of the children and stuff like that they had, and they called it palimony, P-A-L.
I remember.
Yeah, palimony. But if you don't, out there they recognize it for some, but that's California, which means their law is meaningless and nobody pays attention to what happens. I was told that in law school. Anything that comes out of the Ninth Circuit, don't pay any attention to it because it's always wrong.
Yeah, it gets overturned every time.
When it's not recognized, it means if you go into court and you want a statutory remedy under a statutory marriage, it's not available to you. We don't recognize the marriage, so the remedy doesn't apply because it lacks jurisdiction.
Yeah.
You don't have jurisdiction over a state licensed marriage, and you have a choice whether you want to make it be a state license or not. But you're not going to get those remedies. Now, I don't think that's that big of a deal.
Yeah.
So, I mean, you're probably better off without those remedies, in my opinion. I never did much divorce work, but nobody fares well in those.
Nobody comes out good in divorce.
Those legal remedies are just, nobody's happy. So anyway, that's what recognize means. But in the full faith and credit clause is a little different. They're going to extend full faith and credit to all other jurisdictions' laws, and they will use those laws in that state so people don't have to do that very thing. I mean, people move all the time, think all things you have to, bad enough now, you pretty much have to change your driver's license and maybe your voting registration, a few things when you change, but that kind of stuff, like estate planning and all that, no, you don't have to. Right. Now, I'd say most of the people that do move here feel more comfortable if it's a Tennessee governed documentation, and so we change it for them. So. But there's nothing that says you have to change it.
You mentioned, I think, 2 or 3 times in your conversation there, or common law. Mm-hmm. Now, does that mean it's just recognized across the states? I mean, what is that?
Common law comes from our common law jurisprudence, our history.
Yeah.
Our history, what we do, what we have a prior course of conduct doing, what the courts have said. Okay, mm-hmm. When you have law, the legislator codifies law.
Yes.
Sometimes the word is mispronounced and codified.
Yes.
Anyway, the written law, okay, that's statutory law. Okay. Common law is usually court law, judge created law. Like when something goes to court and the question is, okay, they rule on something.
Yes.
Let's say there's a search and a seizure, and the search is challenged, okay?
Yeah.
And it was like, can you search the trunk of somebody's car while they're in Waffle House eating dinner.
Yeah.
Or something.
Sure,
You know.
sure.
And for some reason, the statute's not hitting the nail right on the head, so they challenge it, and they're running up the appellate thing and said, you know, can you do this? If you actually go read the thing, it gives you the terms and conditions of search and stuff like that, and the issues of privacy. But let's say when you read it, it doesn't quite cover that situation. Then the court will look at it, they'll analyze it under the fundamentals and stuff like that, and determine whether yeah, you can do that, or no, you can't. Okay, and now when that comes down, that's not in the written law, but that is now law, and that's common law.
Okay,
Comes from there.
okay,
Go with like the Supreme Court. What the Supreme Court says, our United States Supreme Court, what that Supreme Court says is law, and that's the end of the appeal. There's no place to go after that.
no place to go after
I mean, what are you
that.
gonna do? Go to the World Court or something? No, it doesn't work that way.
Don't work that way, no.
And and a lot of things become codified law after they do that. Here's an example. 1969, the biggest case to ever come down the pike in the United States Supreme Court, 169-page opinion, was Miranda versus Arizona. Okay.
Yep.
And there was another case in there, which is a guy named Esteban. They cited two cases in the same thing, and it was pretty much the same topic. And that was the one that police were beating confessions out of people, putting cigarettes out on them and burning them until they would confess.
Yeah.
I mean, if you read it, it's all in there.
Yeah.
And that case, we used to talk about precedent, about what's once settled, always settled. That case went so far back. And I always say, if you want to go back and learn some of this stuff, if you go back far enough, you're going to get your feet wet crossing the Jordan River, because it usually derives from our scriptural laws, you know, the laws in Deuteronomy and Leviticus.
Yeah.
Okay? Now, that case went all the way back. The 1609 star chambers that they used to have in England, where they would do that kind of stuff.
Sure.
I mean, it was really cool.
Yeah.
But anyway, that was the case where they said, look, when you a person that's charged with something where he has the risk is if he's going to lose his liberty, which means a criminal offense.
Yeah.
He cannot go forward without an attorney represent him, because the average person is not going to be charged with, or not charged with knowing what he needs to know to defend himself.
Right.
And they made and of course they had to say, well, if you can't afford one, then one's going to be given to you. That was the birth of the Public Defender's Office, and they talked about what you have to say to the person. Okay, you have to read them what they call the Miranda rights.
Yeah.
You have to read that to them. That later they wrote that into the code, because the Supreme Court, that was now law.
Yeah.
So, but they came up with it. It wasn't already there. That's what they came up with.
Oh, wow, wow.
Yeah, and anyway, it's been that way ever since. That's what common law is. It's not codified to begin with, but comes up from something, and the courts rule on it based on history and precedent and other cases, and if they get a question that they just don't know, they look at other jurisdictions that may have answered the question, and they can find what they say, what they do, persuasive or not persuasive. And you know, and. But when it gets to the Supreme Court, and that's the kind of stuff the Supreme Court gets, they get what they call unanswered questions, or a new question of law, and they have to come up with an answer.
Yeah.
You know.
So when we hear the term Miranda rights, that's where this come from, and it was a person.
Yeah, it was Ernesto Miranda.
Yeah. That's interesting.
His namesake was, and he died in prison.
Yeah.
Yeah, that's exactly what.
Wow.
You know, and here's the way my mind thinks, and I brought this up one time, and it stumped the judge.
Yeah. Uh-oh.
I mean, and I never did get an answer. When the police are charged with, when you arrest somebody,
Yes.
and it's very specific. You don't just read your Miranda rights and that's the end of it. There's meaning behind it. What it means is, if you have a custodial interrogation, which means if you're in custody, and that has a whole definition all by itself.
Right.
The policeman walks up to you on the sidewalk, starts to answer your question. You're not in custody. He's not going to read your Miranda rights and tell you, you can't, you don't have to say anything, right? And the reason they have the Miranda rights is, you have a Fifth Amendment right not to incriminate yourself.
Right.
Okay, the police are saying, the Supreme Court says, what does the average guy know? He has a Fifth Amendment right to not incriminate himself, and they say, no, probably they don't. So constitutional rights are so strong, if to waive one, they'll only accept an intelligent, voluntary waiver of one. So, but this kind of thing, they don't know they have it in the first place. So they said, we're going to advise you have this right first. Yeah. And then if you waive it, then you know what it is. It was explained to you, and when you waive it, now it's a knowing voluntary waiver.
Yeah.
Okay, so but it only applies in custody. A lot of people think you just get and read your Miranda warning. It doesn't happen all the time. It only happens if you're in custody, if you're not free to leave, basically.
So it only happens if being in custody means you're being arrested.
Wait, that's right. Once you're arrested, you're in custody.
You're arrested and in custody.
But a lot of times, you know, when I used to do criminal work, they'd get something like a child sexual thing. Okay?
Yeah.
And they'll call somebody up and say, listen, you know, we got this complaint. You know, we'd like to hear your end of the story. Would you come down and talk to us?
Yeah.
And a lot of times they come down. A lot of times they'll start that out and say, look, you're not in custody. If you want, the door's open. If you want to get up and leave at any time, just feel free to do so. We're not keeping you here.
Right.
Now, if you answer questions, you're stuck with those answers. You can't later claim that you didn't have your Miranda right warnings because it doesn't apply because you're not in custody. You have to be in custody.
Okay.
And it's only for interrogations. Meaning, all it really means is if we ask you questions, you have the right not to be a witness against yourself.
Yeah.
So you can refuse to answer or just not answer. You know what I mean? And so they read the rights, and they've changed it a little bit from what the Supreme Court actually had. So
Oh, really?
a little bit, and they basically it's something like this. You know, you have the right to remain silent, and that's derives from the Fifth Amendment that says you don't have to be a witness against yourself.
Yeah, yeah.
Anything you say can and will be used against you, which means if you waive this right, and then you decide to confess anyway, now that's an admissible confession, okay?
Right.
So anything you say will be used against you. You have a right to an attorney. That comes with the Sixth Amendment, where you have to be represented by counsel,
Right.
especially in a proceeding where you face loss of liberty.
Yeah.
If somebody's suing you for money damages, you do not have a right to an appointed attorney.
Right.
I've seen people come into court and say, in a civil situation, somebody's suing, and they say, oh, I can't afford an attorney, so I want the court to appoint one. The court says, well, we don't do that. He said, well, I can't afford one of my own. He said, well, I'm sorry, but you don't get one in a civil case. You only get it in a criminal case. You have to be facing a loss of liberty.
Okay.
And that's going to jail, right?
Yeah.
So you have a right to remain silent. Anything you say can be used against you. If you need an attorney and can't afford one, you have a right to be represented by an attorney. If you
Sure.
can't afford one, one will be provided. That's where the public defender's office came. They get to the end of their Miranda rights, right? And you know, and they say, you don't have to answer questions if you don't want to, right?
Yeah.
They get to the end of the Miranda rights, and now they added and said, do you understand these rights? And I raised in court one time, I said, is that one of the questions my client doesn't have to answer? Right?
Yeah.
Okay.
Yeah.
You have the right to remain silent. Anything you say can and will be used against you. If you have the right to an attorney. If you can't afford one, one will be appointed to you. Now, do you understand the rights that I've read to you?
Yeah. I don't have to answer.
And my client stood mute. I mean, he didn't know. He just didn't say anything.
Yeah.
They said, now what are they going to do? If he doesn't, he didn't say he understood them. He didn't say he didn't understand them. So, I mean, the default has to be he didn't understand them, right?
Yes.
But, my question was, if you're going to frame it like that, you told him he has a right to be silent, and now you ask him a question.
Yeah.
And you want an answer.
Yeah.
Well, anyway.
Only an attorney would think.
It was entertaining.
Yeah, it was entertaining.
Yeah. But, maybe somebody doesn't understand it when you give it to them.
Yeah.
I don't get what you're saying, trying to tell me.
I'm sure you've seen the comedian that was talking about being arrested, and he said, I had the right to remain silent, but I didn't have the ability.
Yeah. Right. I'm getting way off track, but anyway, when I was practicing criminal law, I would tell people that were in jail. I'd get appointed to them, I'd go visit them, I'd say, listen, I'm going to give you rule number one. Rule number one is don't say anything, keep quiet, and shut up. And that's the hardest thing for people to do. I said, you're in custody, they listen to the phone. I said, I'm telling you, they listen to the phone. You're in custody, they can do that. Was that a right of my privacy? No, not when you're in jail.
No.
You have no right of privacy when you're in jail. They listen to the phone, and so many people call their mom or call somebody, and they literally confess over the phone. And, then you get to trial, and they bring this thing in, and you can't get rid of it because, it's...
Anything you say can and will be used against you?
Well, even then they're in custody, so that doesn't, but they claim it's a violation of my right of privacy, and it's not you don't have a right of privacy. Privacy is another thing that's court common law. Because if you read through the Constitution of the United States, nowhere will you find the word privacy.
Really?
It's not in there. They derive it out of the right to pursue life,
liberty, and
pursuit of happiness.
Yeah.
The pursuit of happiness is where the right of privacy is derived from.
Okay.
Yeah, but that's not in there.
Interesting.
A lot of words are not in the Constitution that you hear on TV all the time. I don't know. I was watching Fox News, and what's in Al Green, the guy the one congressman that waves his cane all around all the time.
Yes, oh yes.
And the guy was talking to him. He says, "Are you going to protect illegal aliens?" He goes, I support the Constitution." He says, "The Constitution deals with Americans and illegal aliens." It's like, okay, I would like to.
Yeah, I saw that.
I would like to maybe sit down and explain to him the words during the Constitution.
And he knew better than that. I hope he knew better than that. And it's two-edged. If he knew better than that, shame on him. If he didn't know better than that, shame on him.
Now, criminal rights, like the Miranda that I just mentioned to you,
Yeah.
that applies to anybody that's here, border to border or shore to shore.
Yeah.
If you're present in this country, those rights apply to you. Not all of them. The criminal rights do. You have to afford the criminal rights to somebody that commits a crime here. You have to afford those rights to them during the trial process and the prosecution and stuff like that.
Yeah.
But it doesn't say anywhere in the Constitution that illegal aliens get what he's talking about.
Yeah.
So, what bothers me is you got a guy that's in Congress and he doesn't understand what the Constitution says. I mean, you hear him misquote it all the time. It's aggravating to me because are we really asking too much for them to know and understand the fundamental document that governs our jurisprudence and our...
Well, sadly, a lot of them don't really care about that. They want it the way they want it.
Yeah.
Instead of the way the Constitution says it should be and has to be.
And Congress is collective.
Yeah.
I mean, let's take the deportation statutes and all the stuff that ICE is going on. And you got congressmen that say, I'm against that. And say, wait a minute, how can you possibly be against it? You wrote the law.
Yeah.
And then there was a congressman that said, no, I didn't write that law. It's like, well, you knucklehead. Congress wrote it collectively, which is what you are.
Yeah.
You don't come in and say, well, I wasn't in Congress when that law was written, so therefore I'm not going to support it. That's sedition.
Yeah.
I mean, they should be...
And they should know better.
Yeah.
And I think they do, shame on them, and if they don't, shame on them.
But they get away with it. Nobody calls them on it.
Yeah.
Or vice versa. I mean, anyway, they all do it. It's not just...
I used to, Stan, for many, many years, I guess I would have been opposed to term limits, but I'm not anymore. Because there's too many career people that are up there for 40 and 50 years.
So you are opposed to term limits? I mean...
I am for them.
You're for them, yeah.
I'm for term limits.
I am too.
I used to not be, but I am.
It was never intended to be a career.
Yeah. But,
it was a public service. You did it you donated your time as a public service. You didn't used to get paid for it.
Yeah.
When we started out, you didn't get paid for being a congressman or something.
Well, they vote themselves so many benefits, including the ones where they get to stay in office as long as they want to.
Which is right. That's right.
So, it's crazy.
Anyway, let's see if we can get back to our...
I guess we need to... I guess I need
answered
to steer you back into estate and estate planning.
We never did give the phone number, and it's probably too late to give it now.
766-9393. We've got about 10 minutes if someone wants to talk.
But I do think I answered those two questions, so...
yeah, absolutely. Absolutely.
But those are interesting concepts.
Yeah.
I get those questions from time to time.
Well, it's interesting, just the conversations that you and I have had over the years now. I've learned a lot, and of course I deal with estates as far as liquidating estates, that kind of thing, and run into stuff. And one of the things that happens too is the kind of the cleanup process. Yeah, we find where maybe there's a note somewhere that nobody knew about. Those kind of things.
Real estate law can, in my planning practice, can get pretty dicey sometimes.
Yeah.
The ownership that comes up, so many times something comes up and it's like, man, I sure never saw that coming.
Yeah.
We just stumble across it.
Yeah.
There was one not too long ago. It was just a classic. Gentleman come in. He was with his son. He was single, and he wanted to do a trust plan. I said, great. We did our intake, talked about all this, and I said, what real estate do you own? Because when we do a trust plan, we got to put the real estate into the trust, and I do that for them. I write the deed that deeds it to the trust. So he had a place, he had a home, a primary residence, and so we go and get it, and lo and behold, it was still titled to him and his wife. And so I asked him, I said, who's Brenda, or whoever it was,
Yeah.
Who's Susan? He said, well, that's my ex-wife. And I said, well, when were you ex-wife? He was like 37 years ago. Okay. It was a really long time ago, right?
Yeah, yeah.
I said, well, we got a little bit of an issue because the house you're living in, the property you have, is still titled to the two of you.
Yeah. Oh, yeah.
He said, well, how can that be? We got divorced and we settled all that. And they said, oh, apparently not, because the last deed in time is this one.
Yeah.
So I thought, okay, how are we going to resolve this? Because we're going to have to reach out to Brenda and ask her if she'll agree to transfer it to this trust that leaves it to his son, and I think we did. And all of a sudden she was like, "Oh, I'm on the deed too." It's like, "Yeah." I said, "Well, I think maybe I'll just hang on to my part of it then."
Yeah. Which she could have done.
Which she could have. So I looked into it a little further, got into the archives, and it turned out, I figured, well, this has got to be something from the divorce. So I pulled the MDA, the Marital Dissolution Agreement.
Yeah.
And in that agreement, it said he was supposed to give her some money. It's like $2,000 or something.
Yeah.
For something.
Yeah.
What it was for, it doesn't matter. So, but it's part of the agreement. He gives her $2,000, and she was supposed to deed the property back to him. Well, he never gave her the money, and she never deeded it back. And they were still arguing. It was like, well, she was supposed to give me some guns back, and then I was supposed to give her the money. She never gave it to me, so I didn't give her the money, and she never deeded the property. And now they were starting to say, well, I'm not going to agree to let you. No, it was supposed to be his.
Yeah.
Now, the people really at fault are the lawyers that represented them. They should
Yes.
see through that the MDA was carried out. Of course, they didn't, and it's 37 years went by, and it wasn't.
Yeah.
That's malpractice. And anyway, but I told them, I said, listen, you guys are going to start getting back and forth on this. As far as I'm concerned, you're both in contempt, and if I have to take this to court, that's how they're going to see it. A court order ordered you to do these two things, and
Yeah.
neither of you did it. So 30 years, I mean, they'll make an example of you because that's what they do for contempt. I said, so just suck it up and do it. Let's do it now. And now, in other words, it's late, but we can still fix it.
Yeah.
Okay, because nobody complained for 37 years.
Yeah.
I'm not complaining now. I just found it and said, I can't deed this property to trust with a co-owner that won't sign off on it.
Yeah.
So I said, so they did. They saw the wisdom in that and thought, I'm not going to go to court and explain why we didn't do that.
Yeah, exactly.
So I don't remember if he gave her the money or not, but she agreed to sign the quitclaim deed, and she did, and so he transferred it.
Yeah.
But it was like that was never done. It's been that way all the time. It surfaced, and fortunately, it's a fixable thing.
Yeah.
If we just act reasonably, like reasonable people, we can usually resolve those kind of things, and we did. So
Hopefully, every so often you run across an unreasonable, but it happens.
Oh yeah, I have a unreasonable request on a trust administration as we speak. So it's I don't know. And the statute says you're entitled to reasonably keep people informed. When you're administering a trust, and somebody gave us a list, a multi-page list of, and everything starts out with any and every and all receipts, any and like for all time.
Yeah. Yeah.
And it's like, well, this is unreasonable, so we're.
Yeah.
The law typically uses the word reasonable, and you can rely on that a lot because it means what it says.
Yeah.
It doesn't mean unreasonable. Of course, sometimes you may need the court to determine what's reasonable and what's unreasonable.
Yeah.
Anyway.
Yeah.
Anyway, as we're slowly approaching, let's.
Couple things. Is there anything going on at the theater?
Yes, tonight's the opening of Your Good Man, Charlie Brown.
Oh, really?
Kids show, yeah. It's going to be a couple of weekends.
Oh,
So,
that'll be neat.
And then we had our very second rehearsal for 1776 last night. So we're in the beginning stage now. We actually had one of the music rehearsals, and so that's in the very beginning phases.
Yeah. And
I think we still have one spot open because somebody couldn't continue and bowed out. And it's we have a lot of roles in there where you maybe have one sentence to say
Sure.
the whole thing.
Yeah.
And if you sing it all, it's in a group song, which means you don't have to sing if you don't want to.
Yeah. Yeah.
Or if you can't, you know what I mean? If you can't, don't.
So that's in anticipation of our 250th.
Those performance dates are in the month of May. Okay.
Okay.
The actual ones escape me, but it's a Friday, Saturday, and a Sunday for 2 weekends in May, and then the following weekend they have I think we already have a Saturday holdover show.
Okay. Very good.
Meaning, it's scheduled if there's a need for it.
Yeah. Okay.
Holdover shows are when people
Yeah.
want to buy a ticket and they're missing all the shows, and so we do it to
Yeah.
satisfy.
Absolutely.
So anyway, and that's a good one. I'm directing that.
Yeah.
I'm also got a small role, and I'm going to play John Hancock. And
John Hancock.
The reason I do is I'm at a desk, a little bit elevated over the Congress, and I know the play very well, but I can keep the scripts available on my desk. And first of all, I'm directing it. Everybody's going to know their lines when I direct. But what happens is, evidently or eventually, somebody's going to forget a line or drop a line.
Sure.
And then people panic and they don't know how to recover from it.
Right.
And I'm relatively experienced on the stage, so my job is going to be to draw it back. I can ad lib and make it sound like it's supposed to be there. To bring it back.
Yeah.
Ben Franklin's sleeping or something, and his line comes up, and he's just sitting there stargazing like this happens to some people. As Congress, I can say, Dr. Franklin, you have an opinion on that?
Yeah.
You know, he'll look at me and he'll go, ooh, oh. Yes, and then they'll say his line, you know. So, I mean, in live theater that happens.
That
If somebody
happens.
can't say their line.
That's what's fun about
it.
it.
Can't
though.
come to a screeching halt, so it has to keep going.
Yeah.
You know? And you want to make it look pretty seamless to the audience, of course. So
That's what's fun about seeing a live play like that,
yeah,
though.
yeah. I mean, there's always something that happens. Someone drops something, or
Sure.
some backstage, or something doesn't work.
Yeah.
When we did it one year, the music just went south for this one song.
Yeah.
And it was Rutledge from South Carolina, and he sang the song a cappella.
Oh, wow.
He just when he realized it wasn't coming, he just started, and there was no music. He did the whole thing a cappella. It sounded pretty good as far as I was concerned.
Just did okay.
Like, that's a tough thing to do.
It is a
and
tough.
I don't know if he hit the notes great, but if there's no music compared
matter.
to
That's
it,
right.
it's easier to. But I mean, stuff. And at the end, he was like, we got the next break. He gets off stage and he's like, "What the hell happened with that?" And we found out that I don't know the tech area, something happened to the music, and we had to go re-download the music because it went to play and it wasn't there.
Wasn't there.
And the person at tech booth was like, "Oh my!" They can't yell down, "My music's not working." But you just have to deal with it on the spot, and that's what. And it's scary, but it's also very kind of cool. You know, it's
cool.
fun to do that. So yeah, tickets will be on sales at some point.
Well, good deal.
So,
Good deal.
yeah.
The Star Theater's always got something good going on over there.
Yeah, yeah. And I used to, my office used to be right beside it. It's not there anymore. I'm 2 blocks away. I'm right on the West Jefferson Street. If you could see through the courthouse, you could see one office of mine from the other.
Well, good deal.
But just catty corner, 1 block off the square, and we like it. It's like a house. We really outgrew our old building that we're in. We had stuff stacked in every nook and cranny, and this is like a house. And it's real nice. You know, the different rooms of the house are offices or waiting rooms.
I need to visit your new office.
Yeah, it's pretty cool. Stop in sometime.
Yeah.
And the seminar's coming up 3 weeks from tomorrow, which is March the 28th, and that's going to be here at the WLX radio station in the back of the building. They call it the Country Cafe. It's not a cafe, but that's what they call it. It's a big venue. They do picking and grinning and dancing on Friday night, so it's a lot of room. But if you come to the radio station up front, it's probably going to be locked. So just go to the back of the building, you'll see a set of double doors right in the parking lot. You really can't miss it. It's just not labeled. I put my sign out there, but it usually blows over, so I don't. But nobody's had too much trouble finding it in the past.
Yeah, a lot of people know where it is anyway.
I once had a couple call me, and they were coming from about 3 hours away, and they said, "Well, we'll just stay at the cafe and eat lunch then when we're there."
Yeah.
I said, "Well, it's not exactly that kind of cafe."
Yeah.
I said, "But there's plenty of places to do that."
That's right.
But that's not really one of them.
That's right. That's
So
right.
it's we call it Will's Trust in the Nursing Home, and the physical address, if you need it, is 1212 North Locust Avenue in Lawrenceburg.
That's
so
right.
Come to that. That's March the 28th at 10 o'clock. It's a Saturday. It's at 10 a.m. We try to start as promptly as we can.
Well, give me your office number.
Yeah, if you want to talk to me about anything, except some of the stuff I talked about today, because I don't do that stuff anymore. But call me at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222. You can go to my website, which is estateplanstand.com. You can look at my calendar, see where we're going to be, or you can read some of the cool stuff that's on there, or get my email and ask the question that way. So,
Good deal.
we are in Pulaski. My office is located in Pulaski, like I said, just 1 block off the square.
Yeah.
Call and set up a question. If you call, the girls will schedule a time for me to call back, and I will.
Very interesting conversation this morning, I think.
Yeah, kind of all over the place.
A little different than sometimes, but
And sometimes it ought to be that.
but very, very good.
And you can tie all that stuff into estate planning. All the stuff that's happening in the world today. It might be a good time to have your estate planning in order, because not sure what's going to happen next.
Estate Plan Stand, everybody. Estateplanstand.com.
Yep, and we're estateplanstand.com.
That's right.
Yeah, that's right.
And 363-7222, the office number. And also, I was gonna remind you and tell you that I am going to be taking a little vacation time next week.
Okay.
I won't be here, but somebody will.
Okay.
Somebody will be here.
I'll get Box or Charlotte.
Either Box or Charlotte, one of the other.
If not, I'll just stand here and talk
You
to
may
myself.
just have to wing it.
I'll talk to myself if nobody shows up.
Yeah, taking some family time off during the spring break and
Good for you.
and all that kind of stuff. So we're going to be away next week, away from the station anyway. Kind of a stay, what they call a staycation, maybe that kind of deal.
Okay, staycation. Yeah.
Something like that.
Well, it's always a pleasure, Jeff.
All right, thank you. See you next time.
FD Lawrenceburg. Broadcast services.